Tonight, the task of introducing the speaker is a great privilege. As a part of continuing legal education, the Kerala Federation of Women Lawyers invite to the fourth session with the topic Trademark Infringement, a chanter to the judicial interpretation. When we hear about trademark, there is a likelihood of confusion in the which is focused in the trademark for infringement. Now, the need of trademark is to be considered is in three-pronged approach to represent the goods. For example, helping the customers recognize the source, helping the customers to determine the quality, helping the customers to purchase the purchasing decision, to make a purchasing decision. Now, when we come to the trademarks in India, earlier it was considered in it was considered with the Specific Relief Act 1877. Section 54 was the section which was it has been dealt, and as far as registration was considered, it was considered under the Registration Act 1908, and thereafter in 1999 the Trademark Act come into existence. Now, when the trademark comes into existence, the legislation that protects the trademark in India, and it was for the registration, protection, and penalties against the infringement has been penned down in the Trademark Act. The trademark is given to a status of intellectual property across the globe for design, patent, and trademark. Now, it has been controlled by each and every organization in each country. In India, it has been controlled by Indian Patent Office, administered by the Controller General of Patents, Design, and Trademarks. Now, what is trademark infringement? It is nothing but unauthorized usage of a mark that is identical or deceptively similar to a recognized trademark. For example, when we go to a hypermarket, what we do? We are all busy today. We simply grab things and put into our baskets. Now, there are people particularly notes the expiry dates or the manufacturing date, but there are people only note about the color of the products and then they put into the basket. Now, when the right has been infringed, they find some difference in taste. Then they understand there is some difference in they go to the look up onto the pouch of the product. Then they find that the rights has been infringed. That is where they find that it has been infringed, but nothing can be done by the time. So the people are not aware of the infringement of the rights. Now, there is deceptively similar. For example, deceptively similar means people, for example, if it is Sam Milk and Sunsilk, starting with S, ending with K, Sam Milk and Sunsilk. It's a sachet. It is personal experience of mine. I have received a sachet naming Sam Milk with the same printing and same color of the Sunsilk. So there is an infringement. So this is not, if we are not aware where to go, how to go, and how to register a case. If you are not aware, you are not able to go. So here this act come into the scene. That is a Trademark Act 1999. And now I would like to present a glance of the biography of the eminent speaker present today. That is Dr. Elizabeth Workey, Advocate, High Court of Kerala. Now, she was a visiting research fellowship of AHRDB, Research Center of Studies in Intellectual Property and Technology Law, University of Edinburgh, Scotland, Economic and Social Research Council, Genomic Forum, University of Edinburgh, Scotland. And she's also having a handful of books written: Law of Patents, Law of Plant Varieties Protection, Intellectual Property Principles and Practice, which is published by Eastern Book Company, Lucknow. There are some selected articles: Shielding Farmers' Rights, Journal of Intellectual Property Law and Practice, Oxford University Press; Patenting of Medical Methods, Need of the Hour, Journal of Intellectual Property Law and Practice, Oxford University Press. There are some important presentations also: Public Lecture on Traditional Knowledge and Folklore, an Indian perspective under the banner of AHRB Research Center for Studies in Intellectual Property and Technology Law, University of Edinburgh, Scotland. Presentation on highlights of the Patent Amendment Act 2005 with reference to pharmaceuticals at the Royal Society of Chemistry, London. Presentation on plant variety protection and farmers' right at ESRC, Genomic Forum, University of Edinburgh, Scotland. Presentation of design and patent at the workshop on fast-changing scenario in the COIR Exportal, organized by the COIR Board, Government of India, Ministry of Micro, Small and Medium Enterprises. There's yet another presentation on legal protection of traditional knowledge at the National Seminar on WTO, India and Emerging Area of Trade, organized by the Indian Institute of Management, Kozhikode. Chaired a session at the National Seminar on WTO and Emerging Areas of Trade, organized by the Indian Institute of Management, Kozhikode. Now, the glimpse of the biography itself shows how eminent the speaker, today's speaker, is to take the class on trademark and a trademark infringement. I, on behalf of Kerala Federation of Women Lawyers, welcome you, madam, for today's session. Over to you, ma'am. Thank you.
Thank you, Ranjita, for the nice words. I think we can have a screen sharing. I have a few slides for you.
Yes, ma'am. I'll make you the host so that you can share the screen.
Am I a co-host? Can I share the screen?
No, you are not made a co-host. I'll just make you the co-host right now.
Okay.
Yeah, you are the co-host now.
Okay. Okay. So, good evening, friends. Now, let us start with the discussion on trademark infringement, a canter through judicial interpretations. Am I audible to all of you?
Yes, very well audible, madam.
Okay. So, the importance of trademark has been well illustrated by Advocate Ranjita. As she had said, the main intention of having a trademark is to identify the source from which the goods emanate and also to know and also to ease customer identification of the product. As she had said, normally we go to a hypermarket, pick out a product without just going through the whole of the label and then rely on the manufacturer or rely on the trademark, buy the product. So that's the usual way all of us buy a product. So that is where the importance of trademark creeps in. So what is the rationale of trademark? Other than the source identifying function, trademark has many other functions as well. The most important function of trademark from the viewpoint of the owner of the trademark is the goodwill associated with the trademark. The owner of the trademark always values the trademark as a goodwill and has investment for developing the trademark. Normally, a great deal of research and development goes behind a trademark so as to come out with a distinct trademark, which will enable the customer to identify the product easily. So that itself helps the public to get the product they want and also to identify the source from which the goods emanate. Now, what is a trademark? Trademark is usually a sign. It usually signifies the goods and also that the particular goods originate. It's not alone the goods, even the services fall within the category of trademark. So both the goods and the services originate from a particular source. So that is the main function of a trademark. Another requirement for a trademark in order to obtain a protection is that the trademark should be capable of being represented graphically. Unless there is a graphical representation, a trademark owner will not be able to obtain a registration for the trademark. So that is one of the greatest drawbacks when coming to non-conventional trademarks, which I shall deal with in the next slide. What are the different types of trademark? There are a host of trademarks like words, labels, shapes, words written in special scripts, logos, and so on. And now, of late, we have some trademarks which we call it as non-conventional trademarks, of which smell, sound, scent falls. So as you could see in the slide, there is a Coca-Cola bottle, there is a Air India trademark, there is a Cadbury trademark. All these trademarks are entitled to protection under the Trademark Regime. The next is a sound mark, which is a non-conventional trademark. A non-conventional trademark is a trademark which was not initially thought to be fit to be considered as a trademark. So when we started recognizing trademark as a mark which is capable of registration, initially sound mark, sound, smell, and scent did not fall within the category of trademarks. Of late, we have recognized sound marks, smell marks within the category of trademarks, which we call it as non-conventional trademarks. In India, we have registered a trademark for Yahoo's Yodel, which was the first trademark to be registered in India. The famous sound marks, which was registered in USA, even prior to India giving registration for sound marks, it was being registered in the US. It is, as you can see, the sound of the famous Tarzan yell. All of you must be aware of the Tarzan yell. And the sound of the famous Tarzan yell is a registered trademark in USA. Likewise, the lion roar of Metro-Goldwyn-Mayer Corporation. Most of you must be familiar about the lion roar in the Metro-Goldwyn-Mayer Corporation. When we go to a movie, you usually recognize that the movie originates from Metro-Goldwyn-Mayer Corporation by the sound of the lion as well as the logo of that lion. Once you see that, you identify the movie as originating from a particular source. So that serves as the identifying purpose of a trademark. Then another trademark which has been registered in the US is McDonald's Fine Note Jingle. I am loving it. Another trademark which of late is coming in the Western countries, which is not being recognized in India, but you have registrations for these trademarks in the US, is a texture mark. All of us are using many fabrics, many bottles, many other goods, which is having a particular texture. The issue was whether these texture, which is something distinct, could be registered as a trademark. As I have already told you, the trademark requires the mark to be represented graphically. One of the greatest hurdles for registering a texture mark is that the texture mark is not capable of being represented graphically. So that was the hurdle point which is being faced by the developed countries to register a texture mark. In India, we have not started registering texture marks, and no application has come up for registration of texture mark as well. So texture marks are those which give the feel of the product through touch. Just like smell marks, it is difficult to be registered as there can be no representation of the feel of the texture. It is difficult to represent the feel of the texture. Even then, in US, there has been a registration of a texture mark. And in that case, the graphical representation was satisfied by means of a old par bottle was reproduced on the printed page of the IP Gazette by a dual printing process in which the inked portion was printed first and then it was followed by a second raised impression or embossed printing of the texture mark itself on the same page so as to qualify the requirement for graphical representation. You see the old per bottle on the slide, which has been registered by the Ecuador Institute of Intellectual Property. Now, what is the main requirement for registration of a trademark? A trademark to be registered has to be something distinct. Unless and until the trademark is distinct, you are not entitled to get a registration. So the requirement of graphical representation coupled with distinctiveness is one of both are major requirements for obtaining a trademark registration. In this particular case, the name of Robin Hood, you can see it on the slide. Robin Hood represented in a particular manner with an archer standing in it, a historical figure, and the last letter in the name portrayed as a target. This particular trademark was registered for the reason that that was a distinct trademark, which has a distinct representation of a figurine as well as a target and a archer. There are not all the trademarks are registered. Even if the trademark is something distinct, certain trademarks do not qualify for registration. The categories of trademark which do not fall within the ambit of registration are descriptive words. Descriptive words means the word, the trademark itself signifies either the quantity of the trademark or the quality of the trademark or its geographical origin or other characteristics. To give you an example of a descriptive trademark, a 10-liter, if you have a trademark like 10-liter bottle, the 10-liter bottle qualifies the product. It shows the quantity of the product and thereby prevents registration of the mark as a trademark. Another trademark which do not qualify for a registration and which falls under the category of descriptive word can be a trademark like perfect arcs. The word perfect qualifies the mark which is denied a protection under the Trademark Act. Now you have certain common or generic names like cellophane tape, which should be always free for all to use. The logic behind not registering a common and generic name is that it should be free for all to use. You cannot confine a trademark to a particular person, which is a generic word. So that is why you keep the generic words out of registration. So common and generic names are not entitled to a registration. Then another category is shapes necessary to achieve a technical result. If the shape itself requires the achievement of a technical result, then that is not entitled to a protection. That category, I think I'll explain in the next slide because it needs a further bit explanation to be more clear to all of us. Another category is the specially protected emblems, like emblems of the Government of India or other such emblems. Those which fall within the specially protected categories are not entitled to a registration. Now, functional marks. This would fall within the earlier slide in the category of shapes necessary to achieve a technical result. You need to achieve a technical result, and the shape, that particular shape, serves the function of the product, in which case that shape cannot be registered as a trademark. So marks which serve a function is not entitled to registration. You see the three-dimensional Lego brick, which they applied for a trademark registration, that was denied a trademark registration for the reason that the shape of that three-dimensional Lego brick is intended to achieve the technical result, and so that should not be granted a trademark registration. So which we call it as functional marks. Same is the situation of Kit Kat, which has the four-finger shape mark. They applied for registration of the four-finger shape mark, and that was considered as not being entitled to registration. It is the presence of the grooves which gives the product the shape which is necessary to obtain the desired technical result. And the technical result which was intended to be achieved was to enable the consumers to easily separate the wafer fingers. So in order to achieve that technical result, that particular shape was necessary, and so it cannot be granted a trademark protection. So any shapes which serves as has a functional result is not entitled to a trademark registration. Now, what are the main types of trademarks which can be considered as an ideal trademark? You have any number or n number of trademarks which can be considered as ideal trademarks, though now we consider those trademarks as a common or generic word, but still those trademarks, when it was invented, was an ideal trademark. For example, Facebook, L'Oreal, Cartier, Yahoo, Lego, Kodak, and any number you can find. So once that registration is obtained, then the distinctiveness is is not considered in the case of a registration. Next category of trademarks. You have many trademarks which you consider as well-known trademarks. All of you are aware about KFC trademark with the Sanders head on the top, which is a well-known trademark. They have registered the trademark as a well-known trademark. So that is being registered as a well-known trademark. Then Emirates, BBC News, all these trademarks are considered as well-known trademarks. And any copying of such well-known trademark is considered ipso facto as in bad faith. You need not further prove bad faith in the case of such well-known trademarks. It is considered, any copying is considered as in bad faith. The next is the recent trends. When you say, as I have said earlier, you have many trademarks which are now coming up for registration, which falls within the category of non-conventional trademarks. I had said earlier about smell marks, scent marks, and now what is a smell mark? A smell mark is a mark which gives a particular smell to a product. And by virtue of that particular smell itself, that product is distinguished as originating from a particular source. The biggest hurdle for registering a smell mark, as said earlier, is the issue of graphical representation. And now in India, we have not registered any smell marks because it fails. Most of the smell marks fails the test of graphical representation. And any graphical representation, if made of a smell mark, is usually considered as describing the product and not the particular smell. But in US, a high impact fresh floral fragrance reminiscent of plumeria blossoms was entitled for registration as a trademark with sewing thread. The next is a scent mark. All of us are using different kinds of scents, and most of you would be familiar with channel number 5. The question is whether you are entitled to registration of the scent mark, channel number 5, as a trademark. And the answer would be a big no. The reason is that a scent mark is not entitled to registration because since it is usually considered as functional. The scent or the olfactory character of that particular mark is due to its function of the product. And as stated, as I had explained in the earlier slides, a functional trademark is not entitled to a registration. That is what usually the scent marks fails registration. Let me take you through the various steps of registration of a trademark at a quick glance. You'll have to file an application with the trademark registry with the appropriate fees. And once it is filed in the trademark registry, the examiner will examine the application, give you an objection to the application. If required, you can answer to the objection. Then there can be a hearing. Post these 2 stages, the trademark will be advertised in the trademarks journal, at which point any person finding the trademark as infringing their mark can file an opposition. In case there is no opposition, the mark will proceed to registration. After, there is also a provision for appeal from the decisions when there is an opposition. What is the duration of protection? The duration of protection for a trademark is 10 years from the date of application, which is renewable from time to time. The registration is conclusive evidence of validity of the trademark. Now, what are the rights which you obtain by reason of registering a trademark? Registration of a trademark confers on the holder of the mark the right to sue for infringement of trademark. You are entitled to initiate an action for infringement in case of any violation of a registered trademark. So that is the biggest achievement of a trademark holder, because he'll be entitled to obtain initiate an infringement action. Now, what happens if a trademark is not registered and you find someone else copying your trademark? At that point, even if you have not registered your trademark, you have a remedy of availing a passing of action. So the passing of action, though a common law remedy, still the holder of the trademark is not left remediless, but he can file a passing of action. What are the exceptions? If you have a honest and concurrent use of the mark, two marks, almost similar marks, existed side by side for quite a long period of time, you consider those marks are honest and concurrent use. So both the marks are entitled to coexist. Since it has coexisted in the market for quite a long time, you consider those marks are entitled to coexist in the market. So that is the concept of honest and concurrent user. Another principle, another exception is a prior user. So a prior user of a trademark is always entitled to a superior position than a registered holder of a mark. So if you can prove that there is a prior user of the mark, even if you are faced with an infringement action, if you are able to convince the court that there has been a prior use of your mark, you can wriggle out of the infringement proceedings. Then if there is a dishonest adoption by the proprietor, then adoption of a well-known foreign mark, all these calls for an infringement action. Now, is it a defense to claim, to say that you have a registered trademark in a passing of action? In a passing of action, even if you have a trademark registration, if the person who initiates the action has a prior use of the mark, he is entitled to the trademark and you are considered as infringing. And the only permitted use of a registered trademark is the licensing of the trademark, which has to be entered in the registry subject to quality control measures. So that is considered as a permitted use of the trademark. So as I have said, there are two kinds of remedies available in the realm of trademark law. One is a statutory protection under the Trademarks Act, for which you can file an infringement suit. Another is a remedy under common law, which you call it as a passing of action. Now, a quick run. What is infringement? If you use an identical or similar mark as that of a registered mark, you are considered as infringing. And that use should usually be with respect to a similar or identical good. So if you are using a trademark on a totally different product, that will not usually be considered as infringing, but such situations, the question would be whether the extent of reputation enjoyed by the trademark holder or the length of time for which the trademark was used would be considered by the court. So in such situations, if you are using a trademark on a different product, normally it is considered as non-infringing. A run through the different judicial interpretations. This is one of the earliest cases, K.R. Chinnakrishna Chettiar versus Sri Ambal and Company. Both the trademarks, those were they were dealing primarily with snuff. Both of them were snuff dealers, and they started using. They applied for the appellant filed an application for registration of a trademark for snuff manufactured in Madras, and then the respondents, they filed a notice of opposition, saying that the appellant is not entitled to registration of the trademark because they opposed it mainly on the ground that they have been using the trademark, as you find in the slide, they have been using the trademark Sri Ambal Snuff as a word mark, as well as a label mark, in which there was a globe, there was Sri Ambal on it, and the added materials. So they opposed the trademark when the appellants applied for registration of the trademark. The appellants, they claim that they have that was a kind of, I searched the searched for the appellant's trademark, but I couldn't get it on the site. So I'll explain what was the trademark. That was there were 3 panels. And the 3 panels, the first and third panels contain in Tamil, Devanagiri, Telugu, and Kannada the equivalent of the words Sri Andal Madras Snuff. And the center panel contained the picture of goddess Sri Andal and the legend Sri Andal. So the question was whether the label mark, which you find on the slide, infringes the mark of Sri Andal Madras Snuff, or whether both one is a copy of the other. It was held that the word Ambal being the essential feature of the trademark and the word Sri is only a subsidiary part of it, it was found that both the trademarks were almost similar, and an imperfect recollection of the trademark, or if you see Sri Ambal and then later you see Sri Andal Snuff, both the ocular comparison was same. So it was found that the name Andal does not cease to be deceptively similar because it is used in conjunction with the pictorial device. So that was the final decision in this case. The next is Vicks Vapor Up Salve and Keros Vapor Up. Both of the Vicks Chemical Company were the proprietors of the registered trademark containing the word Vapor Up, and another trademark consisting of a design of the words Vicks Vapor Up Salve. The defendants advertised their ointment as Keros Vapor Rub. The question was whether one was infringing on the other. The main concept of trademark is not side-by-side comparison, but if you are using the essential feature of the trademark of another person in your trademark, you are considered as infringing. In this case, the words vapor up was considered as infringing when being used by the defendant. So a mark is infringed if even without using the whole of it, another trader uses the essential feature. So the main concept is the essential feature of the trademark. The next is the case of glucose biscuits. Childhood days, all of us used to eat glucose biscuit, any number of glucose biscuits. So all of you must be familiar with the packet of glucose biscuits you see on the slide. The essential feature of the glucose biscuit is a girl with one arm raised, carrying something in the other, with a cow, hens, and chickens in the foreground. In the background, there is a farmhouse. The words glucose biscuits in one, and the defendants, they were using a trademark. That also I couldn't get hold of the trademark of the defendants. I'll explain how their mark was. The defendants were using the trademark. The wrapper of the defendants also had a girl in it. The girl was holding some hay in one hand and some food items in the other, and they argued that the plaintiff's animal featured a cow, whereas there was only a calf, and there were slight differences between the buildings in the background. So these were the main contentions raised by the defendant. The court found that though the essential get-up has to be considered, and though there are minor differences between the girl, the essential feature of the whole mark was the words glucose, or rather gluco, which figured in both the marks. The girl figured in both the marks, cow figured in both the marks, and it is immaterial whether it's a cow or a calf. And the court came to the conclusion that there has been infringement, and there was a good deal of similarity between the two writings. So the essential feature test is the most important test in the case of a trademark. That is in the case of an infringement of a trademark. Next is Pidilite Industries versus Poma X Products. In this case, a trademark which is identical or phonetically visually similar to a registered trademark amounts to infringement. You can see both the trademarks on the slide. Fevikwik, Quick Heal, both uses the essential features Fevikwik, which amounts to infringement. Next is the famous case. Next is another case, KFC versus KFC European Fried Chicken. In this case also, the dispute was with regard to the words FC figuring in both the marks. One is a word mark and the other is a device mark. You have a cock prominently displayed on the mark European Fried Chicken, which according to the defendants, they argued that the cock, which is an essential feature of the mark. And finally, this case was settled out of court. What is a trademark in relation to a pharmaceutical industry? The most consumed product nowadays are medicines. You go to the medical shop, buy a medicine by name, rather than going to who manufactures the product. So any similarity between the names is considered as infringing. A stringent view is taken with regard to infringement of trademarks in the case of pharmaceutical industry. So any similar sounding, the test which is adopted by the courts as well as the registry is more stringent than any other court with regard to a pharmaceutical product. These are some of the instances wherein it was found that the mark is not entitled to a registration for the reason that it is sounding names. Liv 52, Liv T, Energix, Lipicard, Lipicor, all sound similar, and so they were not entitled to protection. Lakshmikant versus Chetan Bhai Shah. This is one of the most important cases in the trademark regime, which is usually cited in almost all the courts. In this case, plaintiff was running Mukta Jeevan Color Lab and Studio in Ahmedabad. The defendant, the plaintiff, was using the trademark Mukta Jeevan Color Lab and Studio for quite a long time, and the defendant, who was using the trademark Gokul Studio, one fine morning decided to change his name to Mukta Jeevan Color Lab and Studio. He claimed that the studios were around 5 kilometers apart, and so there was no question of infringement. Interestingly, the lower courts found that the argument of the defendant was right and that he was not infringing. The matter reached the apex court. The apex court came to the conclusion that the adoption by the defendant of the trademark Mukta Jeevan Color Lab and Studio of the plaintiff was infringing. That was an attempt, dishonest attempt to ride on the reputation and goodwill of the plaintiff. Mahindra and Mahindra Paper Mills Limited versus Mahindra and Mahindra Limited. The word Mahindra was at issue in this case. And when we usually talk about registering names, normally we are always asked whether you are entitled to register your name as a trademark. In this particular case also, it was Mahindra which was at the core of the issue. Usually you say a name is not entitled to a registration. A name, surname, forename, they are not entitled to registration, prima facie. But when you obtain a secondary meaning for that name, you are entitled to registration of the name as well. So in this case, Mahindra was not only a registered trademark, but formed the dominant and significant part of the plaintiff and other companies of the group for over 5 decades. The apex court found that utilizing the name Mahindra or Mahendra on the ground that the mark, it has acquired a secondary meaning. It was found that nobody is entitled to use those words for the reason that the word Mahindra had attained a secondary meaning. So normally you say you are not entitled to a trademark registration for a name or phoneme unless you have a secondary meaning associated with that name. One of the latest decisions of the Delhi High Court. You find any number of cases from the Delhi High Court on trademark law, and most of the cases from the Delhi High Court has interpreted almost all the provisions of Trademark Act exhaustively. This was a case wherein the word super was at the core of the issue. You can see the plaintiff's packaging and the defendant's package. The question was whether the word super being used by the plaintiffs in their packaging and being used by the defendants in the packaging infringes on the trademark of the plaintiff. The plaintiff had trademark registration for the label mark, for the words super cutest, any number of registrations using the words super and adjoined with some other words. So the question was whether the defendants, by using the words super pants in their packaging, had infringed on the packaging and trademark of the plaintiff. The word super, whether can be entitled to a trademark protection. The court found that the word super, as it is descriptive and laudatory and is not entitled to a trademark protection, or rather the word super cannot be considered alone to claim a trademark infringement. The court found that the color scheme is different in both the packages. The name Dabber is written prominently on the packaging of the defendant, and there are enough added material to see that there is no infringement of trademark by the defendant of the plaintiff's packaging. Though there was a consideration as to whether the word super is entitled to a can be considered as infringing, the court found that the words added material like dabber and the use of the word super by the plaintiffs themselves as qualifying the product itself takes away the distinctiveness and makes the words descriptive and laudatory. Bright Life Care versus Mini Cosmetics Private Limited. This was a case in which there were many videos released on the YouTube, and the plaintiffs had registered many trademarks as well as many logos which used the word Siddhi. Siddhi who may, Siddhi, they were primarily relying on the words Siddhi. The words Siddhi usually connoted in the language as someone who is not ready to give up something. So the plaintiffs were selling Muscle Blaze trademarked products as protein supplements. The defendant company was also involved in the manufacturing of pharmaceutical and Ayurvedic products, and they started using the words Siddhi along with their products. Like they used the words Siddhi perfume. They manufactured perfumes and started selling perfumes with the words Siddhi perfume. So there were many videos being played in the court, around 4 commercials, which are the subject matter of the present suit, of which one is a boxing ring. You find both the boxing rings similar. You find a person working out with a rope, even in the defendants also, the person working out with a rope. And the other slide which you find is a person who, after working out, was very weak, and then he was consuming a drink of the plaintiff, and the background Firse Sidkar was being played. Almost identical. You find the defendants also had similar YouTube versions. So the court finally found that though the word Siddhi was a descriptive word, still the defendant having copied the entire mood, the court found that the entire mood, the setting, you can see the plaintiff's advertisement and the defendant's advertisements, both set in background, which is very a black background with very few lighting. Almost all the features of the plaintiff's advertisement was similar to that of the defendants. So the court found that the defendants was infringing on the plaintiff's mark and were piggy riding on the reputation of the plaintiff. And the defendant was restrained from using the trademark. GlaxoSmithKline Consumer versus Abbott Laboratories, that also says that laudatory epithets may be used by a manufacturer, but if you want to claim a exclusivity over the trademark, you need to explain or show a higher element of distinctiveness. Those laudatory words or descriptive words, I do not say that it's not at all entitled to a registration, but it requires a very high element or very high pedestal of distinctiveness in order to entitle you to get a registration for such laudatory or descriptive words. Next is a Supreme Court judgment in which the earlier slides also, I was stressing on the essential features of a registered trademark, and it is the essential features of a registered trademark which has to be considered when you find or when you see whether there is an infringement of a trademark or not. Since we are running short of time, I think I'll skip through some of the slides so that we finish it off within time. Now, what is the right of a proprietor, registered proprietor of a trademark? A registered proprietor of a trademark is entitled to obtain a relief for infringement of the trademark. So that is the situation in the case of American Home Products, National Bell Company. Now, next you come to Satyam Infoway case. Most of you must be aware about the Satyam Infoway case. That was one of the first cases which dealt with whether domain name is entitled to be considered as a trademark. And the court came to the conclusion that a domain name has all the characteristics of a trademark that identifies the source of the domain, and so there can be an action for passing off in the case of a domain name. Internet domain name, it is a valuable property, are important and has importance to the parties and has a right equivalent to that of a trademark. So that is with regard to domain name registrations. Now, statutory remedy of infringement, and then you have a common law remedy of passing off when there is no registration for a trademark. For a passing off action, the requirements are there should be a misrepresentation, and the misrepresentation should be made by a trader, which should be in the course of the business, and the misrepresentation should be intended to prospective or ultimate consumers of goods and services, and that should injure the business or goodwill of the other person. So there should be an actual damage to the person by whom the action is brought. So these are the major requirements to be fulfilled for a passing of action. This is a case in which there was no registration for the trademark. And since there was no registration for the trademark, only a passing of action would lie in this particular case. The plaintiff's trademark was Sarkari Result. The plaintiff also had a registered domain name, sarkariresult.com. The defendant started using the trademark sarkariresult.info and sarkariresult.india. And the question was whether the defendant had passed off their goods as that of the plaintiff, and whether there has been a damage caused to the plaintiff. The court came to the conclusion that the use by the defendant of the words Sarkari was intended to injure the reputation or goodwill of the plaintiff and was intended to cash in on the reputation which was developed by the plaintiff over the years. Remedies for trademark infringement. You have a criminal action would lie for trademark infringement, or when another person is using your trademark, you have a remedy of criminal action that would lie under the cheating, then counterfeit property marks, and then criminal conspiracy. The most widely used remedy is a civil remedy of injunction. So these are basically the main concepts of trademark, and I have only given you a run through the cases because since we are running short of time. So thank you.
Now to the questionnaire session. Anybody having any questions?
Hello, ma'am.
Yes.
Am I audible?
Yes, tell me.
Ma'am, I want to know whether the 2017 guidelines of trademark has, the rule 124 has created a new procedure, that is by paying 1 lakh rupees and by fulfilling certain criteria, trademark owner can register his trademark as a well-known trademark.
A trademark owner cannot ipso facto get the trademark registered as a well-known trademark by paying 1 lakh rupees, but there is a procedure through which you'll have to undergo prior to getting your mark registered as a well-known mark. You'll have to apply in the required form, pay the requisite fee, pay the requisite fee along with supporting documents. And once the registry is convinced that your mark is a well-known mark, you're entitled to a registration. It's not that you just pay off the money, you're entitled to a registration.
Okay. Do you consider that the rule would enable owners of trademark, owners of certain marks or owners who have got very high capital in promoting and showing their advertisement or sale turnover, etc., etc. Could they easily attain the status of well-known mark? Do you think so?
That cannot be. That cannot be. Unless you are able to convince the registrar, then there is a provision of filing an opposition, and all the other procedure, as in the case of a trademark registration, will follow.
And also, I came across a case in which Tata is a party, I think Tata Airlines or something, in which the court had already declared the mark as a well-known mark, but the registry is trying to fulfill the procedures as such. Even if the court has decided the mark to be well-known, actually the officials, that is the registry office and all, are pushing or are asking for procedural formalities.
I think the procedural formalities will have to be complied with, because that's the requirement of the act, and that would depend upon the facts of the case, wherein the court had whether the court had finally decided to give a go-in for well-known trademark.
Okay. Okay.
That will trademark, as it is primarily a branch of law, wherein you have more of facts than of law, and most of the cases are decided on facts. You cannot give a straitjacket formula other than broad principles being laid down. You cannot have a straitjacket formula in all the cases, because it depends more on the facts of each case.
Okay, ma'am. Thank you.
Ma'am, I have a doubt, ma'am.
Yes.
Yeah, when we upload a YouTube video, as you said in the slide, when we upload a YouTube video, there is some word which is infringing. How would we come to know that it infringes his right if another video is made? Unless and until he come into or he watches the other video, how does he come to know?
You have to be always conscious of your rights. If you want your right to be protected, you have to be. There is something called a trademark watch. Most of the reputed trademarks, they have a trademark watch. They are constantly monitoring whether their marks are being infringed. To tell you in short, there was a restaurant in, I think it is somewhere in the north, that was named as Sony. A very small restaurant. A high official from Sony Corporation happened to pass that way. He found the hotel. He initiated action against that hotel, very small restaurant. He initiated action. I personally know that case. So he initiated action against that restaurant, and the name of the restaurant was changed to Sally. So that is how reputed trademark holders keep a watch of their trademark and initiate action at the first instance itself. It's always to be on the watch.
If they doesn't come in watch or they doesn't notice, means that infringement is not be noted.
That will be continued. That will be continued. You'll be the loser.
So is there any watch, or is there any section to avoid that sort of infringement?
No, unless you bring to the notice of the court, or unless you give a notice to cease and desist using your registered trademark, you cannot help it. If you sleep over your rights, that is where you say you cannot sleep over your rights. Not alone for trademark. Not alone for trademark. Any right, if you sleep over your right, you are losing your valuable right.
Thank you, ma'am. Thank you.
Hi, Elizabeth. I'm Asha Chirian. Now, you are just telling about the infringement. Is there any time limit, means any limitation? So after 10 years, I am noticing the name of the hotel. Can I say that?
Yes, you just say that, that was the first time you came to know about that infringement. You can say you can initiate an action.
Yes,
So the date on which you come to know of the infringing action is the time period from which the limitation runs.
Thank you.
I think
that
was renamed as
Kartika, you're not audible.
the restaurant that you mentioned now in North, which is initially called as Soul,
Yes, yes,
after
yes. It is now renamed as Sani.
that. That's the
Yeah, it was earlier Sony.
So yes.
You will not imagine Sony Corporation suing a small restaurant in North for infringement of their trademark. That's how they keep watch over their trademark.
I think Vidya, even KFC has had 1 or 2 cases. Kentucky Fried Chicken.
Yes, yes,
I think
Parvati, I think,
local places.
yes, KFC and EFC, that was the case which I was referring to in my session. KFC and EFC.
No. Even K itself,
Yes,
I think some local
yes,
place,
they were able
started
to fight
wrestling
out
this.
around 2 or 3 instances, they could fight it.
I know.
FC, they were relying not on K, but they were emphasizing on the letters FC. They did not want the letters FC to be used in any of the trademarks.
Yes, that's right.
Ma'am, may I ask a question?
Yes.
Ma'am, my name is Advocate Jason, and I'm a student from IUCAPRS. And my doubt is regarding to, as per the Article 16 of TRIPS agreements provides that exclusive right to prevent third-party use. And the proviso of the said, the above said TRIPS agreements says that the right prescribed above shall not prejudice any existing prior right, nor shall they affect the possibility of members making right available on the basis of use. And my doubt is that the article precisely says that it shall not prejudice any existing prior right. My exact question is regarding whether existing right, which include GI right also, or well-known mark right or GI right also.
The scenario in the case of GI, trademark, copyright, patent, all are different. So when you talk about GI, we can talk about GI. If it's trademark, it's trademarks. In the case of a trademark, a prior user has a superior right over the registered holder of the trademark, which I had already said in my slides. The prior user always has a superior right. Not alone the TRIPS agreement, in any trademark act, you find that the prior user has a superior right, even if it's a registered trademark.
There are precisely says about well-known mark owners, right? Is it any existing right means? Is it mean well-known mark holders, right?
Yes, well-known mark definitely. Well-known mark definitely has a superior right. Any adoption of a well-known mark, because well-known mark is usually granted only after a procedure, after undergoing the procedure, after verifying whether it's a well-known mark, even in other countries. So usually well-known mark, the reputation is considered not with respect to our country alone, but with respect to foreign countries as well. You'll have to prove their reputation in other countries as well in order to obtain a registration as a well-known mark. So, well-known mark always has a superior right, and any adoption of a well-known mark is considered as in bad faith.
Okay, thank you so much.
Hello, ma'am.
Yes.
Ma'am, can a GA be the word of a GA be trademarked?
GI, basically, when you speak about GI itself is a collective mark. You cannot, an individual cannot hold a geographical indication. It always signifies a collective effort. It belongs to an association or a group of persons. So an individual cannot get a trademark registration for a GI.
A collective trademark?
Collective mark, yes, can be a collective mark. But depends, that should pass the test of distinctiveness as well. So that's why I said the requirement for GI, requirement for trademark, all are distinct. So different. When you talk about GI, it's not the distinctiveness which is considered. When you talk about trademark, it is distinctiveness. When you talk about copyright, it is originality. When you talk about patent, it is novelty. So the requirements for each branch of intellectual property is different. You talk about design, it has a different combination of requirement. So each branch of intellectual property, you cannot give a straitjacket formula that you can apply such and such a test for all the intellectual property. Each category has its own different requirements to be fulfilled prior to obtaining a registration.
Okay, ma'am. Ma'am, I have another doubt also. Regarding the McDonald's case, I happened to see a case in which the South Africa, a person was having a local restaurant named McD even before registration of the original McD in South Africa long years back. But then actually in the territory of South Africa, the actual person who first used the mark in McD was that person who was actually an African. But then later McD sued him. So in that particular case, actually the case was won by the McD. But wouldn't it be considered as a prior use in the territory of?
See, intellectual property laws are national laws. It's not an international law, it's a national law. Depends on the laws in South Africa, one. The second is, might be the McDonald's would have been registered as a well-known mark. Prima facie gives you an impression that the other one is using it in bad faith. You will have to go through the facts of the case as well as the evidence which was deduced before the court to come to a conclusion whether the McD, the win of McD could be considered as something which could be appreciated or not. So that depends on various factors like evidence adduced, the law in South Africa, and all those things. So it's not an international law, but it's a national legislation.
Okay, ma'am. Thank you.
Any more questions? So I think, shall we wind up the session, ma'am?
Yes, if all the questions are finished.
Yeah, with the permission of everyone, I am winding up the session. And the duty bestowed upon me is to say the word of thanks. I, on behalf of the Federation, thank you so much, ma'am, for the wonderful session. Trademark has been not so familiar to many of the members here, I think so. So you have just explained all the concepts in a very clear, crisp, and a very easy way. We were taken through all the judgments for the past 50, 60 years. Thank you so much, ma'am. Further, I would like to thank all the members for sparing your valuable time, and also the Kerala High Court Association for arranging this platform so that we could have such a wonderful session here. So thank you so much for one and all present here. So winding up the session, see you all in the next class. Thank you.
Thank you. Bye.
Thank you. Thanks a lot. It was a wonderful session.
Thank you, Bhargavi. Thank you. Bye. Thank you.
So it's your thoroughness and your expertise that allows you to explain it in such lucid and simple language.
Thank you, Kartika. Thank you so much.
Definitely, definitely. Very much looking forward to seeing you here, on other specific subjects as well.
Sure.
Specific areas of trade.
For arranging such classes.
Okay, bye.
Okay.
Thank you. Bye.
Good night.
Good night.